Within the bar and the bench, there has been considerable confusion about the applicability of Section 397 to 401 and 482 of the Criminal Procedure Code of India, including which court should be approached first are the points of discussion today. As of now, the Honorable Supreme Court of India has settled this issue in the case of Asian Resurfacing of Road Agency Private Limited versus CBI, that the order framing the charge is neither purely an interlocutory order nor a final order, and that the High Court's jurisdiction does not depend on the petition's label, such as Section 397 or Section 482 or Article 227 of the Constitution. A prominent question that has been haunting the bench and the judiciary is which court should be approached first, since under Section 397 of the Cr.P.C, both the Sessions and High Court have concurrent jurisdiction. After exhausting the remedies under Section 397, can the remedy under Section 482 of the Cr.P.C be invoked? And it is important to know whether the High Court can be approached under Section 482 despite the remedy available under Section 397 of the Cr.P.C. All these questions are interconnected, and the answer is that the powers of the High Court under Section 482 and Article 227 of the Constitution of India are unfettered, which can be accessed regardless of the remedy available under Section 397 of the Cr.P.C. Further, the provisions of Section 397(1) of Cr.P.C are as follows: to satisfy itself or himself as to whether any finding, sentence or order made by an inferior criminal court within its or his local jurisdiction is correct, legal or proper, or is in accordance with the law, the High Court or any session judge may ask for and examine the record and as to the regularity of any proceedings of such inferior court, and may, when calling for such record, direct that the execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on bail or on his own bond pending the examination of the record. Here the explanation is all the magistrates, whether executive or judicial, and whether exercising original or appellate jurisdiction, shall be deemed to be inferior or lower to the sessions judge for the purposes of this subsection and Section 398. The Section 397(2) of the Criminal Procedure Code provides the following: in the event a person has applied under this section either to the High Court or to the Sessions Court, the other shall not entertain any further application by the same person. There is no bar to approaching the High Court as a result of the statutory provision. There is only one bar in the section regarding the revision petition, which can only be exercised by the court within its jurisdiction. In cases where a revision petition is filed against an order of the Court of Sessions, only a High Court has the jurisdiction over the revision petition. As a matter of fact, if a revision petition is dismissed by the Sessions Court, it cannot be heard again by the High Court. Accordingly, as an example, if X has filed a revision petition against Y under section 397 of the CRPC that has been rejected by the Court of Sessions, he cannot file the revision petition again in the High Court. It was held in the case of CBI versus Gujarat that there is no statutory limit on which court can be approached first, Session Court or High Court, and this decision has been referred to and reiterated in various High Court decisions. And now we will talk about the application of 482 when 397 to 401 are still applicable. In section 397(2) of the CRPC, it stipulates that any interlocutory order passed in an appeal, inquiry, trial or other proceeding shall not be subject to the powers of revision conferred by subsection 1. The Apex Court ruled on the inherent powers of the court in Madhu Limaye versus State of Maharashtra. A bar under section 397(2) to entertain a revision application regarding interlocutory orders cannot be said to be a bar under section 482 of the CRPC, as section 482 of CRPC is an independent section of 397 to 401 of the CRPC, which confers extensive powers on the High Court. The Supreme Court reiterated in Raj Kapoor versus State that section 397 does not prohibit section 482 of the CRPC, which means that the inherent powers of High Courts cannot be affected by other provisions of the section 397 of CRPC. Remedies under section 397 to 401 of CRPC has been a judicial hodgepodge for years. Recently, the matter was finally resolved and determined. There has been two conflicting judgments regarding this. V.V.L.N. Tobacco Products versus State of Maharashtra and Mohit alias Sonu versus State of Uttar Pradesh. The V.V.L.N. case established that even if you have a remedy under section 397 to 401 of CRPC, you can invoke the inherent powers of the High Court through section 482. However, Mohit versus State of UP held the opposite, that you cannot invoke section 482 of the CRPC if the remedy can be sought through section 397 to 401. As a result of these two conflicting judgments, Prabhu Chawla versus State of Rajasthan resolved the issue. The three-judge bench held and clarified the law, deciding that the available remedy under CRPC would not be held as a bar to make a petition under section 482 of CRPC. The judgment was based on the fact that section 482 starts with a non-obstinate clause, namely, nothing in this code shall be construed as limiting or affecting the inherent powers of High Court to make such orders as may be necessary to give effect to any order under this court or to prevent abuse of any process of any court or otherwise to secure the ends of justice. Accordingly, such full jurisdiction cannot be barred from exercising. By repeating the same, Justice Krishna Iyer said that abuse of the court's process or other extraordinary circumstances excites its jurisdiction. Another reasoning which was given regarding the same was that section 397 is only barred by section 397(2), that is, in terms of interlocutory orders. The limitation is self-restraint but nothing more. If held otherwise, section 482 would become limited to only interlocutory orders, which cannot be the case and would be irrational. In light of this, it has been decided that remedy under section 397 of the CRPC does not preclude the same remedy under section 482. Now the question is, can 397 to 401 be circumvented through section 482 of CRPC? According to Rajan Kumar Manchanda versus State of Karnataka, the remedy under section 482 cannot be invoked once the revisional petition is filed under section 397. As a result, if the opposite were true, section 397 and 401 would become redundant and every revision petition there was rejected and not granted a favorable judgment would be reopened under section 482 of the CRPC. Basically, every application facing the bar of the section 397(3) would be labeled as one under section 482 of the CRPC. As a result, there is no way to circumvent the statutory bar. While this case was referred to a higher bench and overruled, but it was still cited and used in State of Punjab versus Devendra Pal Singh. Section 482 of the Code of Civil Procedure describes the inherent powers of the High Court. A High Court's inherent powers are not those conferred by the Code, but those it already has. The Code merely preserves these powers. Section 397(3) of the CRPC merely prevents unnecessary delays and multiple proceedings in the same case by requiring a speedy trial. What happens if the High Court has made an error in the judgment which has resulted in grave injustice? Then it was held in the case of Krishnan versus Krishnaveni. It is intended to invest continuous supervisory jurisdiction on the High Court under section 483 and section 397 read with section 401 to prevent miscarriage of justice and correct irregularities of the procedure or to execute justice. This is the purpose of section 483 and the conferring of the revisional power upon the High Court. Having considered section 397 to 401 and section 482 of CRPC, we conclude that the revision before the High Court under subsection 1 of section 397 is prohibited by subsection 3 thereof. The High Court is still empowered to exercise its inherent authority under section 482 of the Code, since section 483 entails the supreme power of continuous superintendence. The High Court may interfere with the order that has resulted in a miscarriage of justice and set aside the lower court's order. Consequently, a High Court can still invoke its inherent powers when there is a grave injustice or infringement of principles of justice and equity, despite the fact that the decision against the revision petition cannot be circumvented per se. If there is a grave injustice, the remedy still can be sought, and the decision under section 397 to 401 does not bar it. Rajan Kumar Manchanda versus State of Karnataka stands overruled since the Krishnan judgment was decided by a 3-judge bench and the former by a 2-judge bench. Many cases have cited and reiterated the findings of Sudhakar Prasad versus the government of AP. In this case, it was once again clarified that the decision under section 397 to 401 of CRPC is circumvented, appealable only if the petitioner suffers any serious prejudice in order to overcome the statutory bar under section 397(3) CRPC. Proving grave injustice is a must if the petitioner wants to resort back to section 482 of CRPC against a decision under section 397 of Cr.P.C. In summary, if a person having gone for revision under section 397, if he wants to invoke again the jurisdiction of the High Court under section 482, then he has to prove that there is a grave injustice that was caused to him, and only then he will be in a position to resort to section 482. Not only that, he also has to prove that his case is an exceptional case to be considered under section 482. And also, the litigants cannot use section 482 to dehorse the Cr.P.C when the trial is on its way. So, section 482, after availing section 397, cannot be availed just to delay the trial without any exception being shown for the criminal cases. Hope the information is useful to you all. Thank you very much for your patient hearing.